Good morning, everyone, and good afternoon to those joining us from Europe and Turkey. Today, we are discussing maritime disputes in the Eastern Mediterranean and international law. We have an excellent panel of experts. Um, I would say the premier experts on this issue, especially those who know Turkish position, Turkey's policy really, really well. Um, they are joining us from Turkey. Um, we have with us Çağrı Erhan, rector of Altınbaş University, and he's also a member of Presidential Foreign Policy and Security Committee of Turkey. We have Professor Yücel Acer. He's a professor of international law at Faculty of Law in Ankara, Ankara Yıldırım Beyazıt University. As you all know, uh, lately there's been a lot of tension in the Eastern Mediterranean, and there's a complex set of issues, including the Aegean Islands issue between Turkey and Greece, the Cyprus issue, the recent natural gas discoveries, the debates about transmitting that gas to Europe, and then, of course, the EU's attitude. EU countries are also debating among themselves how to handle the recent tensions. Some, led by the French President Macron, are talking even punishing Turkey, imposing sanctions on Turkey, while others, led by Germany, are more for talks, and Turkey has expressed its intentions to continue the talks and find a diplomatic resolution of the issue. And of course, last year's maritime delimitation deal between Turkey and Libya has been also very significant in these developments. Um, so as I said, we couldn't find better experts to discuss these issues, a highly complex set of issues that involves a lot of the international law that many people don't necessarily know very well, and there's a lot of disinformation and misunderstandings out there. So we feel lucky to have both Professor Erhan and Professor Acer. My name is Kadir Üstün, by the way, Executive Director at SETA DC. I want to welcome them, and I want to welcome those of you who join us on Zoom. This, uh, this session is also being broadcast live on social media. Thanks for joining us. And I will turn to Professor Acer. Um, Yücel Hocam, thank you for joining us. Please make your introductory remarks and outline for us what the main issues are in the Eastern Mediterranean and how Turkey sees the recent tensions. Thank you.
Thank you, Kadir. I also thank you for inviting us here to talk to many participants, actually. Uh, as you say, there have been quite a huge tension in the Eastern Mediterranean recently. Um, I think there are two main points concerning these tensions. First of all, it's not a new tension, although it is publicized quite frequently nowadays, but it is not a recent tension. It about started early 2000 actually, especially 2003. And secondly, many tensions are now concerning the resource-related activities actually, and to some extent, it's some military activities as well in Eastern Mediterranean. But legally speaking, actually, behind these tensions, there are quite technical matters, uh, legal technical matters, we can say. It's all about actually sharing the maritime spaces. That's the core of the dispute. Although it seems to be like resource-related problems, but it is actually about sharing the maritime spaces between countries. These maritime spaces are significant not only in terms of resources, it is also significant, maybe more significant, concerning some sovereign rights, uh, not only about the natural resource, but all about everything. There are two main concepts actually behind these disputes. The first one is continental shelf, and the second one is exclusive economic zone. These are maritime concepts, and that's why I start to summarize the descriptions about these two main concepts. Continental shelf, let me share a map actually. Uh, if you look at this map, exclusive economic zone and continental shelves are quite extensive maritime areas compared to territorial waters. Territorial waters can extend up to 12 nautical miles, that's all. But exclusive economic zone and continental shelf can extend up to 200 nautical miles from the shore. In certain circumstances, continental shelf can go up to 350 miles if the sea space is available, especially in the oceans. But in the sea areas like Mediterranean Sea, the distance between countries are mostly less than 400 nautical miles. That means exclusive economic zone and continental shelf can go up to up to several miles from the shores, which is quite extensive actually. There are quite similar legal characteristics of these two maritime areas. Both of them are actually not sovereign areas like territorial waters. Territorial waters is under full sovereignty of coastal state. But these two maritime areas, continental shelf and exclusive economic zone, gives exclusive rights to coastal states only on natural resources. So coastal states have some exclusive sovereign rights only concerning natural resources at the moment. Maybe in the future these sovereign rights may be extended, but at the moment, legally speaking, it's only about natural resources. But if you talk about the exclusive economic zone, it's more extensive than the continental because it also covers the seabed and sea space and covers living and non-living natural resources. So it's quite extensive maritime area. And the problem is actually, what is the rule about delimiting these maritime areas between coastal states? Because they are quite extensive, unlike almost in all parts of the world, we need to delimit these kind of maritime areas between respective coastal states. Especially in the Mediterranean Sea and in the Aegean Sea, there is inevitably, a process of delimitation between coastal states. Because these maritime areas are quite extensive and the sea space is not so extensive, actually, especially when we talk about the Mediterranean Sea. That's why we have a rule in international law to tell the states how to delimit or how to establish the border separating the exclusive economic zone and continental shelf between coastal states. There have been huge discussions what should be the rule, because geographical situations are so different from each other. For example, when we talk about the Pacific Ocean, it's not a problem
Hocam, can you
establish
repeat
borders
that last
because
thing
it's
you said?
quite
Couldn't
different.
hear it. I'm sorry. Can you repeat that last sentence?
Yeah. Okay. There has been huge discussion about what should be the international law rule about delimitation, because geographical situations are quite different from each other. So, since they are quite different natural circumstances, it's not easy to establish a single rule that would provide, let's say, just solutions for all maritime spaces in the world. Other than developing a specific rule, conventional and customary international law developed rather a general rule which says the delimitation should be done to produce an equitable result. So the rule, both in customary law and in 1982 Law of the Sea Convention, it says the state should establish the borders to be an equitable one. So equitable is quite a general concept. That's why, um, judicial decisions about the maritime delimitations are quite important in maritime law because the courts fill these gaps to tell us what means equitable in maritime delimitation. We have many examples, many court decisions, starting in 1969. We have more than 20 cases decided by international courts to tell us what is equitable. Okay, the next point is actually what is the maritime dispute in the Eastern Mediterranean Sea? Actually, although we have a rule in international law, the parties are interpreting this general rule quite differently from each other. And they are not able to agree on the borders, especially between Greece and Turkey, and between Turkey and Greek Cypriots. There are huge gaps in their opinions about how to apply these equitable principles to Eastern Mediterranean Sea. In the center, actually, there are islands. The dispute is actually all about islands. Cyprus is an island, and there are some Greek islands facing to Eastern Mediterranean Sea. So it's all about what would be the effects of these islands on the maritime waters. That's the main dispute, actually. So if the dispute is solved, what Greek Cypriots and Greece want actually in this Mediterranean Sea? Let me again show you. That's the Eastern Mediterranean Sea, a map shows the general configuration of the Eastern Mediterranean Sea. Let me show you a map to show what Cyprus wants. That's an official map presented by the United Nations showing their demanded maritime areas. The Greek Cypriots wanted equal share of Eastern Mediterranean Sea. Equal share means the equidistant line should be accepted by Turkey as well as a maritime boundary. That's what Greek Cypriots want. There is also another map that shows this dotted lines, shows the Greek demand actually. It shows that all the Greek islands in the facing the Eastern Mediterranean Sea, Greece demands equal shares to these islands. That's the Greek and Greek Cypriots demand.
Professor Ajar, we are having some sound issues. Can you try to reconnect because your voice is coming in and out, and
okay.
I'm sorry about that. But I'll turn to Professor Erhan in the meantime. Can you try again? Thank you. Professor Erhan, so hi, we were having some technical issues and the sound was not very clear, but hopefully Professor Ajar will come back with a better sound. So Professor Ajar mentioned a couple of things regarding international law, the idea of equitability, and then all these islands between Greece and Turkey. There is no common agreement between the two countries. That's kind of at the source of all these recent debates and tensions. Like Professor Ajar said, it's been a long time, since 2000s actually. These issues have been outstanding. What is your take on how is Turkey seeing these issues between with Greece and the rest of the Eastern Mediterranean? Thank you.
Hello everyone, good morning to United States, and good afternoon to European friends and Turkish friends. Yes, as Professor Acer stated, that the core, the main nature of this conflict is the existence of the islands in the Aegean Sea. We can count a lot of problems, yes, the territorial waters, the exclusive economic zone, or the FIR line problems, demilitarization of islands problems. But when we look at the basis of the problem, it is the existence of the Greek islands, which are very close to Turkish mainland and very far from Greek mainland. As many statesmen and historians stated, that geography is the fate. We cannot change this geography. The islands are there. Therefore, we have to find some other ways to restrain serious political and military conclusions of a conflict between two NATO allies in the region. Particularly since 1970s, well before the signature of 1982 United Nations Convention on the Law of Sea, Greek governments adopted a behavior to use the Aegean Islands as a tool to disturb Turkey. And it is quite understandable because it was a time when Turkey and Turkish foreign policy particularly was heavily busy with the Cyprus question. When the Cyprus question became a problem between Turkey and Greece, Greece has started to use the claims over Aegean Islands. Particularly, they started to use the, in quotation marks, threat to increase the territorial waters of the islands over 6 miles, up to 12 miles, well before the 1982 convention. Therefore, it is not a right argument to say that Greece has started its claims after UNCLOS. They started their claims well before UNCLOS in late 60s and throughout 70s. When we look to the historical development of the situation, we see after the signing of UNCLOS, Greece started to use the clauses of this convention, particularly about the territorial waters of islands against Turkey. And this created a huge reaction in Turkey. In 1995, Turkish Parliament, in a joint declaration with the signature of all political parties in the parliament, declared that if Greece officially proclaims that the territorial waters of Greek islands is more than 6 miles, Turkey will perceive it as a casus belli, a cause for war. And this parliamentary decision is over there. It is still valid, and all governments came to power after 1995. They recognized the same parliamentary decision over and over. Therefore, it is not, we should clarify, it is not a declaration against Greece Act to proclaim its islands territorial waters for 12 nautical miles. It is a declaration that Turkey sees it as a cause of war if Greece increases its territorial waters in the Aegean over 6 miles. We should clarify this. This is very important. Sometimes in the international public, it is understood if Greece says, yes, we will make it 11 miles, for instance, or 10 miles. It is not a cause of war. No. According to Turkish declaration, any increase over 6 miles is a casus belli. And Turkish-Greek dispute over the Aegean reached its peak in 1996. It is the famous Kardak-İmya crisis. I'm sure many of the audience has an age to recall it. Then United States President Bill Clinton gave a special place in his memoir about this Kardak crisis, because two NATO countries, first time in the history, in the Aegean, came at the brink of a war or an armed conflict. And then United States President intervened to the situation, called Greek Prime Minister Mr. Simitis, then called Turkish Prime Minister Mrs. Çiller, then called back, and after a couple of hours of hard work, he prevented an armed conflict between two important allies in the southeast of NATO. And in 1999, when Turkey was given a candidacy status for the European Union membership, the European Commission issued a document which is called Accession Partnership. According to Accession Partnership document, in order to become an EU member or in order to start negotiations, accession negotiations with the EU, Turkey on one side must obey the Copenhagen political criteria, but on the other side, Turkey must solve its border disputes with the neighbors through good neighborly relations based on bona fide in international law. And positively responding to European Commission's this call, Turkey started exploratory talks with Greece in 2000. Between 2000 and 2016, 60 rounds of exploratory talks were conducted between two parties. I should explain this term exploratory talks because maybe Professor Acer will also touch it. In order to take an international dispute, particularly a legal dispute, into an international court or international arbitrage platform, first of all, the parties must agree upon the nature of the question. And again, they must agree upon the method to solve the question. According to the status of International Court of Justice, if Turkey and Greece once upon a time will decide to take the situation to International Court of Justice, first of all, they should agree upon the question to be asked to the court. Is it a territorial waters question? Is it a continental shelf question? And what kind of law will be used to solve this problem? Will there be the Lausanne Treaty arguments will be the basis, or the United Nations Convention for Sea of Law will be the basis, which Turkey is not a signatory to this convention. Therefore, these exploratory talks started and continued for 60 rounds. In 2016, we don't see on the table any solid, concrete agreement between these two parties. However, at least these 16 years, of exploratory talks, 60 rounds of exploratory talks. These 16 years were also the years in which Turkey was negotiating with the EU. We should not forget this. Turkish-EU negotiations started, officially opened in 2005, and Turkey and EU started to negotiate on the chapters for accession on one hand, and on the other hand, Turkish and Greek foreign offices started exploratory talks to find a solution about the Aegean disputes. But in 2016, they couldn't reach any solid, concrete agreement. However, at least throughout the 16 years, the two parties did not come to brink of a military clash as they had faced in 1996 during the Kardak crisis. So if we look as an objective eye to the success of the exploratory talks, yes, it couldn't find any solution to the situation. Parties are standing where they were standing 20 years ago. They did not change their positions. They are still claiming on the claims they had claimed 20 years ago, but at least we did not have a military conflict between the parties. Therefore, objectively, I may say these exploratory talks has a success if we evaluate in this manner. On the other hand, since the end of this exploratory talks, Greek governments started to violate some international documents which they had previously signed. For instance, very hot issue. Yesterday, maybe many of the audience have saw it on the international media. Turkey issued a now tax about the situation of the island of Chios, which is very close to Turkish coast. It is just opposite to Çeşme in Izmir. And this nav text was about the violation by Greece, the violation of demilitarized status of the island of Chios. So how it happened? Because 2 days ago, Greek government issued a declaration and openly stated that they would conduct military exercises on this island. They would fire some cannons and some missiles in the framework of this military exercise from this island. However, when we look at the Lausanne Peace Treaty, articles about the demilitarization of this island is quite clear. During 1923, when Lausanne Peace Treaty was signed, these islands were under Italian sovereignty. However, when they were given to Greece in 1947, in Paris Agreement, their demilitarized zone, their demilitarized status were also preserved. So it did not change. Both Turkey and Turkish and Greek governments throughout 1950s and 60s repeatedly underlined this important issue. But now we see Greek government openly and clearly violates this situation, and they do not have an intention to hide it from international community. They declare it. We start military exercises on the island of Chios, which has a demilitarized status. Therefore, we see a lot of examples of this kind of attempts around Turkish coast. And some Greek governments, including current one, some members of Greek government, when they make speeches in front of Greek public, maybe for political intentions, They repeatedly speak about increasing the territorial waters of the islands over 12 miles. And this immediately triggers the anger in Turkey, of course. This is an open provocation. Sometimes we see, as international media shown just 15 days ago, some Greek commandos, special forces, with their guns, they go and station in Aegean Islands, which has also demilitarized zone, demilitarized status. Therefore, this continuing violation of the international agreements about the status of the islands sometimes create political anger in Turkey. And we should know this. There are some issues in Turkey and some foreign policy issues are also included, which are fiercely and very hardly criticized by Turkish opposition parties. Turkish-Greek relations is not one of them. When it comes to situation of the islands, when it comes to situation of the sovereignty rights in the Aegean, all political parties, they come together and fully support the government. And we saw it, we witnessed it in this current crisis between Turkey and Greece. Of course, Germany, United States, and some other countries, I particularly mentioned Germany because Germany is the president of the European Council now for 6 months. It will end in the end of this year. They do not want a conflict turn into a tension or a military clash between these two important countries. So particularly Germany, when they started their presidency, asked the both parties to restart the exploratory talks, which has stopped 4 years ago. And this is also important. Chancellor Angela Merkel made a phone call with President Erdogan and Prime Minister Mitsotakis. It was a time when Turkey sent its exploration ship Oruç Reis to the region more than 150 kilometers southeast of island of Kosteliço, Mace. And Chancellor Merkel asked Erdogan to make a gesture to Greece, pull back this ship to Antalya port, and give a chance for a start of exploratory talks with Greece. Erdogan responded positively. And in the lower level of diplomatic mechanisms, the foreign offices started to talk with each other for the preparation of an exploratory talks round, 61st round, in the next round. However, what happened? Greek government decided to sign an agreement with Egypt over Mediterranean, which has claims over some disputed areas in the region, as well as some sovereign areas of Turkey. And this opportunity to start for negotiations has gone from the table. It was 1 month ago, as you may remember. Now, we have another chance. Yesterday, Mr. Mitsotakis, Premier of Greece, he said, we can start talks with Turkey. And Turkish Foreign Minister Çavuşoğlu and other Turkish officials, they repeatedly announced that Turkey will not change its position will not step back from its sovereign rights in the area. However, Turkey is ready to sit on the table without any precondition. So I think there is a new chance for the start of these exploratory talks. As I mentioned before, I personally, as an academic, I'm not an expert of international law as Professor Acer, but as an international relations professor, I spent at least all of my career learning and teaching about Turkish-Greek relations. Objectively, sincerely, I do not think any easy and fast solution will come out of these exploratory talks between Turkey and Greece. We should not expect any immediate solution, but at least I support giving a chance for preventing any conflict, I mean military conflict between these two countries. Finally, this is a problem between Turkey and Greece. These two countries previously proved that throughout negotiations, throughout talks, these countries can and these peoples can stand against common threats. We witnessed this during the Second World War. We witnessed this throughout the Cold War. Yes, we had hard times. Maybe problems is a standard for Turkish-Greek relations, but we have a lot of times of solidarity, as we shown during this COVID times. Turkey sent health assistance to Greece. Therefore, these problems must be solved through negotiations between these parties. If they decide to take this to international courts, it is up to their decision. We should prevent any third-party intervention in this region. Unfortunately, we see Monsieur Macron of France found this as an opportunity to take a revenge from Turkey, because he had some conflicts in Libya with Turkey or Sahel region. And he, if I may say, he tried to hit three birds at the same time.
With one stone.
With one stone. First, to take a revenge from Turkey. Second, to clear a space for French energy companies in Eastern Mediterranean. And thirdly, to sell its outmoded weapons to Greece, which has very bad economic conditions with a very high price. Nobody in the world is now using these Rafale air fighters. It is fourth generation fighters. They would send them to the trash. Monsieur Macron now is selling them to Greece. And they are also selling their 3 frigates to Greece. So he has another agenda. So our Greek friends must understand this. We, in our bilateral relations, do not need any third-party intervention. We are destined to live in this region. We will not go back to Central Asia. Nobody should expect this. We are here more than 1,000 years. And I am sure our Greek friends, they don't want to go back to anywhere. We will live here together. Turkish people are supporting peace and friendly relations. We can solve these problems. We need to refrain any conflict or tensions in this region. And finally, President Erdogan last week made a call, an invitation. Maybe because of these tensions, many ears did not hear it. President Erdogan is calling a creation of an economic energy cooperation platform in the region, with inclusion of all coastal riparian states and energy companies. This area is rich enough that all parties, all countries, all peoples can benefit equally and equitarian basis. Yes, thank you.
Thank you, Professor Erhan, for that thoughtful analysis of historical context, but also the political situation between the two countries. And you touched upon geopolitical aspects also. We are running, the time is running quickly, of course, but I want to turn to Professor Acer, and we have an audience question. You did address some of the continental shelf and exclusive economic zone issues between Greece and Turkey. Also, you talked about the islands and islands exclusive economic zones, what they're entitled to, etc. But one question is this, from Ellen Vasilina. I'd be interested to know more about the legal aspects of the maritime delimitations of Greece and Turkey, which court, which institution is competent to judge this? How the UN treaty, I believe UNCLOS 1982 treaty, plays a role here for signatories to the treaty or not? Um, I have an additional question to that. What is the sort of legal basis or international law basis of Turkey's agreement with Libya as well? If you could uh, explain those two, we would be very grateful. Thank you.
Um, I just hope that we are not going to have a voice problem again. uh, I think it is okay now.
We can hear you clearly right now. Yes, thank you.
Um, if there are islands in maritime areas, in everywhere, states are having similar disputes actually over the islands. Because always the dispute runs around this question: what would be the effect of the islands in the region? If there are two countries, mainland countries, and if their coasts are similar extent, and they are facing against each other like opposite coasts. But if there are islands in the middle of these countries, these are always problems between countries. So Greece and Turkey are not unique examples which having these kind of disputes actually. Professor Erhan tried to explain the political aspects, but legally speaking, of course, it's quite usual to have these kind of problems. And in the past, there is actually a couple of quite similar examples in the judicial decisions. The first one we should, I think, as an answer to the question, we should mention the dispute or judicial decision between United Kingdom and France, actually. There are some British islands which are called Channel Islands, which are just a few miles off the French coast. In 1970s, UK and France were not able to settle disputes with negotiations because it was quite complicated, just like Eastern Mediterranean or Aegean Sea. So they decided to take the issue to an international court, arbitration court, which were established by these two countries. In that dispute, the French side was saying that Channel Islands, although they are islands, and there are more than, at that time, more than 130,000 population living on these islands. And France was saying that these islands, if they have equal share of continental shelf with France, then the French continental shelf will be cut off. And it's not equitable to cut off the continental shelf of a continental country just like France, because it has a very long coastline facing the English Channel, just like United Kingdom. And France is not, is not deserved to have very limited continental shelf just because Britain has a couple of islands just off the French coast. And that's the argument on behalf of France. And the court decided that, yes, that's true. Let me show you actually, let me show you map quickly. This is actually showing, this is the map that I would like to show. That's a boundary decided by the court. You know, as you see, Channel Islands were circled around with a limited amount of continental shelf, and there is another main delimitation line between United Kingdom and France. So the court established the main delimitation line. The court called it primary delimitation line, and it gave just 6 miles continental shelf around these islands to these islands. That's because the court said it was equitable to give limited amount of continental shelf if we compare it with a continental country. This is exactly what Turkey is trying to explain to the world, actually, to Greece, first of all. You know, of course, there are Greek islands, but it doesn't mean that Greek islands are, according to international law, deserve to have equal maritime areas. Just international court says if there are such two countries, the delimitation line should be established between the mainlands of these countries. Then later on, and the court will decide what kind of delimitation method to be used to apply to these islands. In the Eastern Mediterranean Sea, if we gave equal share to these islands, let me make a comparison actually. Island of Mace, or Costellarism sometimes it's called, have just 10 square kilometers space. There are a very limited population living on the island, and the island is just 2 kilometers of the Turkish. And Greece demands 40,000 square kilometers of maritime space to this island, just on the base of idea that the island should have equal rights with continental countries. So is it looking like a just one to give 40,000 square miles of space to an island which is just 10 kilometers square kilometers space? That's the problem in the Eastern Mediterranean Sea. And let me also try to answer the second part of the question. Of course, international law says that in 1982 Law of the Sea Convention, it says to the states in 2 articles, Article 74, and you need to settle the maritime delimitation disputes to arrive at an equitable solution, and with an international agreement. So states should settle these kind of disputes with an international agreement to reach an equitable solution. In the Eastern Mediterranean Sea, there have been a couple of maritime delimitation agreements so far. Especially Greek Cypriots made some delimitation agreements with Israel, and then they before that they made a delimitation agreement with Egypt. These 2 delimitation agreements are based on equidistance problem, but it doesn't mean that that should be the same for other parts of Eastern Mediterranean Sea. It's up to the countries to decide a maritime boundary here or there. International allows this, but international law says that if you are in a dispute, then the rule says you should find an equitable solution. That's the rule. If you are not able to settle with an international agreement, it's an option to take the case to an international court, as Professor Erhan tried to explain. That's another option. So international court, or a court that could be established by Greece and Turkey as an arbitration court, may be empowered to settle the disputes on the basis of international law. Concerning the agreement with Libya, just like Greek Cypriots and Greece recently with Egypt, just like these countries try to make an international agreements to establish borders, then quite normally Turkey signed an agreement with Libya to establish a maritime boundary. But of course, it's up to the countries to accept these agreements as a legitimate one. Just like Turkey does not recognize the agreement between Greece and Egypt because it intervenes to the possible continental shelf areas of Turkey. That's quite clear. Just like the agreement between Greek Cypriots and Egypt, again intervening into the possible continental shelf areas of Turkey. That's why Turkey does not recognize these agreements. Of course, it's up to Turkey to recognize or not. That's quite perfectly legal. But the agreement between Turkey and Libya is also perfectly legal for the countries to recognize this agreement. Of course, it was made between Turkish government and Libyan government, which is a national accord government, not a group or illegal group. We are talking about the national accord government recognized by international, recognized by the United Nations. So that's quite a perfectly clear and valid international agreement. One of our
So
audience
you,
said,
so
is
to
there an
just to
international?
clarify, Professor Ajar, you're making a distinction between the international law, whether this agreement is, legal international according to international law, but then whether countries recognize it, accept it, is another matter. And when they don't recognize it, then they either have to come to an agreement or try to go for arbitration. Um,
Yes.
so
Actually, oh, sorry about interrupting.
go ahead.
Actually, the problem was started by Greek Cypriots in the Mediterranean Sea because in 2003, because we knew before that time that the boundaries in the Eastern Mediterranean Sea were actually something disputed. So maritime spaces were under discussion between the countries. Even the uh, Turkish Cypriots, the government in the Turkish Republic of Northern Cyprus before 2003 were actually talking about these kind of boundaries. But, according to 1982 Law of the Sea Convention, these kind of areas, the countries should not, do international agreements without consulting the other interested countries. But this rule was break first by Greek Cypriots in 2003. Before talking to any other country in the region, including Turkey, they signed an international agreement with Greece, with Egypt. That's the first example. Then later on, they continued to sign international agreement with Lebanon, then Israel. So facing this situation, Turkey was left with only one option, and Turkey started to, try to explain its possible rights and started to make international agreement. The first agreement with Turkey was between Turkey and Turkish Republic of Northern Cyprus in 2012. The second one is actually with Libya. So this rule was break by Greek Cypriots and, not to do international agreements in such kind of disputed areas, legally speaking. But if this rule was break, then Turkey was left with only one option, and it is doing international agreements with us.
Thank you, Professor Ajar. There's a couple of questions about international law, but we're running out of time. So I want your answers very quickly, short, because I want to turn to Professor Erhan also because there's some political questions as well. One of the questions, you kind of answered this already, but it says, what would be the impact upon international maritime law and implications for international rules based on order if Turkey violates international treaties like UNCLOS? But Turkey is not a signatory to that agreement, right?
I think the question is about 1982 Law of the Sea Convention or the convention before that one, the Geneva Convention in 1958. I think it's about 1982 Law of the Sea
82,
Convention.
I believe, 82.
As Professor Erhan said, Turkey is not a signatory to, is not a party to 1982 Law of the Sea Convention. It doesn't mean that Turkey is not able to talk about this convention or the rules in this convention. International lawyers know that, many people know that. Many rules are conventional rules, but some of them, or sometimes most of them, could be customary international law rules as well. So, including the delimitation rule in 1982 Law Officer Convention, many rules, including this semi-closed maritime spaces like Eastern Mediterranean Sea, these rules are at the same time customary rules, and the customary rules provides rights and obligations to all countries, even if these countries are not party to this convention. There are only a few rules in 1982 Law of the Convention which are not customary. Most of them became customary rules. And that's why Turkey is perfectly justified to talk about the rules which are also covered by 1982 Law of the Convention.
One last question about international law. This question is on, Greece's peculiar divergence in claiming 6 nautical miles territorial seas, but 10 nautical miles sovereign airspace and its potential impacts on the larger issues being discussed. So I guess Greece, when it comes to airspace, they claim 10 nautical miles. I didn't know that. So can you explain?
Actually, the situation is there as such. Greece is actually applying 6 miles territorial waters in the agency. But since 1931, Greece is applying 10 miles national airspace, which is a unique example. There's no other example. Normally, all the countries have national airspace which is coinciding with the territorial waters extent. Let's say Turkey has a 6 miles territorial waters in the agency, and we also have 6 miles national airspace. Although airspace over the territorial sea can only be national space of a country according to international law. So you cannot claim national airspace larger than your territorial waters extent.
Is that the reason? Is that the reason for those occasional dog fights, quote unquote?
That's right. Actually, legally speaking, you have a national airspace because you declare it. It's not the rule. You have a national space because you have a territorial waters and a land territory. So national airspace is legally, generating from the land and territorial waters. That's why Turkey is not recognizing this extra 4 miles nation in common, 4 miles extra national airspace of Greece. Turkey is not recognizing. To show its non-recognition, Turkish fighter planes sometimes flew over these extra 4 miles airspace, and Greece is actually protesting as if they are violating the Greek nation's airspace.
Very interesting. Thank you for clarifying and explaining that. Professor Erhan, there's a question about the timing of the recent tensions. It says, these issues have been present between Greece and Turkey for decades. Why is this coming up now? Why is Turkey raising this issue at this point, years after much of the gas reserves in the Eastern Mediterranean have been found and claimed? Do you think Ankara government is trying to use this issue for domestic purposes?
I think contrary. Greek government is trying to use it for domestic purposes, because if we look just 2 months, previous 2 months, during the escalation of the crisis, we see a starting point. It is the renaming of Hagia Sophia as mosque in Turkey. So Greek government showed a reaction to this. And when Mrs. Merkel asked President Erdogan and Prime Minister Mitsotakis, as I mentioned in the previous round, to come together on the table, Prime Minister Mitsotakis found it very difficult for himself to explain how to come and sit on the table with Turkey, which reopened Hagia Sophia as a mosque just a weeks ago. Therefore, he opted to sign an agreement with Egypt He opted to leave the table. He opted to ask French military assistance. He opted to take the issue to EU platforms and insistently start to accuse Turkey being an aggressor in the area. Therefore, it is not Turkey which is using the issue for domestic political issues. It is Greece itself. Because, as I stated, I think I must say this many, many times. In Turkey, all political parties are supporting this stance in the region. Erdogan's government does not need any political party to persuade them about the situation. So this Turkish-Greek issue is not something to be used as a political tool. Everybody is, and some of the political parties in Turkey is well beyond Erdogan's position. Yesterday, main opposition in Turkey, they issued a declaration and accusing Erdogan, giving some, they stepping back in the Aegean and asking him to be more firm against Greece. So this is the main opposition in Turkey. Main opposition in Turkey, CHP, is now taking a more fierce, firm position against Greece. Therefore, it is not a political issue in Turkey, domestic political issue in Turkey. When it comes to Cyprus, when it comes to relations with Greece, when it comes to Aegean and Mediterranean, these policies are all supported by the political parties in Turkey. The support for Turkish government's position in Aegean Sea among Turkish public is 90%. The percentage of President Erdogan's last election is not, it is 59%, around 60. It is 90%. Therefore, we cannot make a comment that it is a political issue in Turkey. It is not political issue.
Thank you for that answer. I just want to apologize again for the technical problems at the beginning and give you last couple minutes to just mention things that you may not have had a chance to mention or add anything that you wanted to add. There is, sorry, there's a long question, but okay, well, this is I guess it's a very long question, but why should other countries accept Turkey's position type of question? I'm summarizing this, but I think it has got to do with Israel, Egypt, Greece, this emerging, let's say, coalition on one side in the Eastern Mediterranean. But it's up to you whether you want to address that, but I just want to give you a minute or two to wrap up. I want to start with Professor Acer again. Thank you.
Okay, thank you very much. Actually, we should emphasize as a last point that, all the disputes have quite politically oriented matters, including the internal politics, especially on the Greek side, actually. Governments are using the Aegean and Mediterranean disputes as political matters in the internal issues. That's quite usual. But we shouldn't forget about the legal aspects of these disputes. When we talk about whether this country is right or wrong, we don't only look at the political matters. You may not very good with Turkey. That's quite possible, but it doesn't mean that you may have a right to see Turkey as an illegal country. All the demands and all the justifications explained on behalf of Turkey as an international lawyer, I know that all of them are actually based on the valid and relevant international law rules. In the Eastern Mediterranean Sea, we cannot say that Turkey is unjustified just because there are some other countries making international agreements which are not really acceptable for Turkey. There may be many political reasons, as actually it's the area of Professor Erhan. There are many political complex issues in Middle East and in the Eastern Mediterranean, especially in recent years, and quite huge disputes, including Syria and Libya. In such circumstances, that's quite possible that some states prefer to make an international agreement with another country. It doesn't mean that it is something legal. So Turkey is perfectly justified with many international law rules for demanding such maritime areas. Maybe in the future, we will see that the negotiations will start with Greece again, or they may be able to take the issues to international courts. In both cases, on the table, there would be international law rules to justify the demands.
Thank you. Professor Erhan.
As I said, this is geography and this is our fate. We are living together side by side, and we will live together with Turkey and Greece for centuries from now. Therefore, we have to find solutions. I like to give examples from history in order to understand today. We take some lessons. Let's look what happened after the Second World War between France and Germany. They fought for at least 3 times in 70 years, and they came together. They found the reason for their fight, which was the coal mines and steel industry in Alsace-Lorraine region. And they established the European Union, which was then European Coal and Steel Community. Therefore, President Erdogan's call to come together and create a Mediterranean energy platform is quite important. The conflicting parties in the region, including the parties to Middle Eastern questions, can come together and find the ways to use the rich energy reserves of the area for a common benefit of the peoples in this region. In the 21st century, we don't need more conflicts, military clashes. We need more cooperation. So I think Turkey fully supports, without any precondition, all kinds of initiatives to come and sit on the table to start a new round of exploratory talks with Greece or any party in the region, just to give a chance for peace and a legal solution to the conflict.
Well, thank you very much for that message. I think.
Can I add
Sure.
just one point to what Professor Erhan said quite rightly? As steel and coal used to be a matter of confrontation between European countries and then became a matter of cooperation. In international law, that's also possible for Greece and Turkey to turn the Eastern Mediterranean or regions into a matter of cooperation, because there are many legal options to exploit the area together. Just the president of Turkey recently said that, there would be legally possible, and there were many examples as well, to establish a kind of joint management or exploration management activities in such maritime spaces.
Well, thank you very much to both of you, Professor Yücel Acar and Professor Çağrı Erhan. This has been a very informative discussion. We apologize for the little technical difficulties at the beginning, but I think there are so many overlapping complex issues here, political, legal, also geopolitical, but I think we're going to talk about these issues more in the coming days. These matters are not going to be resolved quickly, like Professor Erhan said, but this willingness to talk, I believe there's going to be a leaders summit towards the end of the month in Europe. hopefully there will be some positive outcomes coming out of those meetings and negotiations. I want to thank our audience as well for following this webinar, and we hope to see you again in the future discussions. Thank you very much to both of you and the audience.
Thank you.
Thank you.